especially at a time if there's a shortfall in government budgets. They want to do absolutely everything they can to not pay out for benefits for a beneficiary with special needs if there's some other source that will take over and pay for it. Hi, this is Jeff Marsacci, the Plain English Attorney, and today I'm going to talk about how estate planning for beneficiaries with special needs doesn't need to be overly complicated. Far too often I hear of attorneys who don't focus on estate planning. They kind of do it as a side gig, and they end up making it a lot more complicated than it needs to be. Or probably even worse, they're not even going to put in the time to understand it a little better and realize, hey, wait, if I can have a standard solution, then I don't have to refer the work out. And that's what ends up happening. If they're doing estate planning as a side thing, they may just say, oh, wait, you've got a beneficiary that has special needs. Forget it. It's way over my head. It doesn't have to be if you're starting with the right documents. All right, so for this one, I'm going to give just a little bit of a shout out to a group that I've done work with for many, many years, in fact, decades. It's the Estate Planning Source. If you're an attorney in the network, you've got access to the documents that they have and put together and print and send out to the attorneys. They're kind of doing a lot of the heavy lifting on having the right language in there. So as I talk about this, if you're an attorney and you're watching this, look, there's a solution to get those right documents. Think of it like you're buying a good, versatile power tool. You do still need to learn how to use it, but you don't have to build a power tool. All right, so good enough on that. So what is so uncomplicated about estate planning for a beneficiary with special needs? Is like, look, if you've got the right documents, good. One note, if you're in a position where you have an estate plan that you want to leave something to a beneficiary who's receiving disability or Medicaid's their health insurance or any other kind of benefit where giving them a direct inheritance is going to cut those benefits off, you do not want to be drafting and putting this in a will. You really do want to go for a revocable living trust as the way to do this, because you end up getting a court involved. And anytime you end up with a court involved, the expenses, the fees, everything, it's just a lot more expensive than if it's handled outside of that probate or guardianship process, and you've got the trust doing the heavy lifting. Right, so it doesn't have to be complicated if you've got a revocable living trust that has the provisions, and here's how this generally works. Inside the standard trust that we do, if there is a beneficiary who has special needs, if they're receiving benefits, it automatically triggers a clause that says, oh, okay, doesn't matter what the age limits say. If it's, oh, well, if they're 40, then they get the inheritance directly. No, this is saying, wait a minute, here's a special situation. That doesn't apply. The trustee is given sole discretion over the use of those funds for the benefit of the beneficiary. They don't have to give them money, and that's key. If they don't have to pay for things, if they don't have to give them money, then these other programs are going to pay for those basic things that they're going to pay for. Especially at a time if there's a shortfall in government budgets, they want to do absolutely everything they can to not pay out for benefits for a beneficiary with special needs if there's some other source that will take over and pay for it. I sometimes see this in trust language. Well, you've got to pay for their basic needs. Well, okay, if you pay for their basic needs, then disability's gone. Any other kind of support, it's gone. Oh, you've got to pay for medical care. Well, okay, that's a basic thing. All right, Medicaid's done until it's drained. No, you don't want that. So it has to be in the sole discretion of the trustee. Again, not complicated. There's not a ton of, oh, well, except in this circumstance, they got to pay for this or they can't pay for that. No, it's just, that's it, flat. Discretion of the trustee. That takes care of it. In the case where we have clients and they have a beneficiary, they already know they're qualified for benefits, or it's likely they will as adults, then we just use that language and trigger it by saying, okay, this beneficiary is going to be treated under that particular section, whether it's actually or medically the case, so it's in the sole discretion of the trustee. It doesn't have to be any more complicated than that on my end, and certainly not on the end of my clients to try to think through all of this. Nope, we're saying this section has been activated and that's the beneficiary. Well, what if something happens, they end up not needing any of these other benefits? Well, it's still locked up, but the trustee can look at the situation and go, well, okay, I don't see a reason why this has to be held back. They can turn over the inheritance to the beneficiary at that point if there's a cure or something that just takes away the need for these programs. Great, it's done. It's all in here, but it's in the discretion of the trustee. Now, one potential exception to this, the most common exception, you still want the revocable trust, you still want those provisions, but if there's tax deferred money, and it's a good amount of money that would be going to this beneficiary with special needs, then you're probably going to want to tack on an IRA trust. Now, with the IRA trust, it has all of the provisions that you would think of for a special needs trust that's out there. And as soon as any money goes into it, it becomes irrevocable. But it's got the specific tax language that allows a trustee to spread the payments out over a 10-year period in the discretion of the trustee so they can minimize taxes and therefore maximize the amount that's kept in trust for that beneficiary. So all those strict lockdown provisions are in there. They can use the money for the benefit of the beneficiary. And then typically, as a practical matter, after the 10-year period, well, if there's other trust money that's equally secure, let's uncomplicate things and add those assets to the other trust. So there's only now one area where all those assets are being taken care of for the beneficiary, and it's done. So not overly complicated, but adding an IRA trust may look and have a significant income tax savings upon inheritance. It might be worth adding. So what are the situations where you may need to have a separate trust and therefore it gets a little more complicated? All right, as a practical matter, for my clients, they're few. There's only three. One, if you're in a situation where you're going to have an estate tax. Now, if we're talking about the federal levels, you've got to have more than $12.06 million in your estate for it to be estate taxable. There aren't a ton of people with that kind of estate, but if you do, all right, then we may end up having a trust that kind of does double duty. It's essentially a special needs trust, but we also fund it ahead of time with life insurance in a way that all the insurance money that's going into it ends up not being part of the taxable estate. Whole separate topic, don't need to get into it now. Second situation, if there are other people who want to leave money as an inheritance to your beneficiary with special needs, usually grandparents, well, okay, then setting up a separate special needs trust to receive that money might make sense. Now, as far as my clients are concerned, that situation is even more rare because usually it's the grandparents' responsibility to set up that type of estate plan and add that specific trust for their grandchild. Third situation, which also involves grandparents, they want to start gifting money now before they pass on. All right, if they're gifting money, they don't want to leave it to the parents. They want to leave it and send it directly to that beneficiary with special needs. Well, then, okay, we need to set up that special needs trust so it can receive the gifts. They get that money out of their taxable estate, off their books, but at the same time, it's not going directly to their grandchild in a way that might mess up benefits. So those are the three situations. Other than that, it's really good enough to just have a solid revocable living trust that contains all of the provisions you need to keep a beneficiary with special needs from they need to continue to receive their benefits. The revocable trust is probably good enough to make that happen without anything else. Now, if you want to get some more information, we've got a special needs planning crash course, but you might as well attend the free webinar that we have first. It's right there in that blue box. It's specialneedsplanningwebinar.com. Go ahead, sign up for the webinar and get all that good information. And then if you want to get more, then it will direct you over to the course. So I hope you found that information useful. As always, please like, subscribe, turn on notifications, keep getting this good information. And as I always tell my clients, stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.